Call the meeting to order. It's again 9 o'clock. Let's start with the pledge of allegiance. Sarah, do you mind leading us? Thank you.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Kim, do we have anyone online?
No, we do.
So I'll skip the reminder. I guess I'll skip privilege of the floor because we're all in attendance here. Do I have a motion to approve the meeting minutes from May 5th?
So move. Second.
All right, all in favor?
Aye.
Any opposed? Tom, you had a comment?
No, I commented on the minutes. Everybody got them about 3 o'clock yesterday. If Kim doesn't have enough, give Kim enough time to get these to us before this, because I'm guessing half of you didn't get a chance to read them.
Okay, duly noted. Tom, you express some concerns just to me right now. Let's talk about that for 5 minutes, 10 minutes, and get everybody's thoughts about those. So what's your concerns?
Enforcement of short-term rentals. We have sweat bullets over an regulation of short-term rentals and maybe a preface comments that every short-term rental diminishes the housing stock for citizens of the town of Canandaigua. And we acknowledge we have to allow them, so we regulate them. We put together a statute. Terry and Chuck, we've been working on this for 5 years. We have flagrant scofflaws. Sarah gave me, I thought it was just a violation of a guy with a lawn sign, which I brought to the attention of 3 of our code guys last September. The lawn sign is still out there. There's a short-term rental living in there this morning. Sarah's name, 3 letters have gone out. There's been no fine. And come to find out, he has no permit for a short-term rental. He lives in New York. He doesn't give a damn about Canandaigua or our housing needs. Why haven't we hit him with a fine as the statute says? Why haven't we enforced this regulation? It's a nickel dime thing, and I have been told that the judges have discretion whether to enforce this code that we put together. It didn't give them latitude. It says fines, violations, something to this effect, and violations will result in a fine. It doesn't say,
if it's
it doesn't say may.
If it's an unregistered short-term rental, can't we act on that right away? I mean, that they're supposed to be registered.
They've been sent 3 letters, right, Sarah?
To register?
So when we find out that there's a short-term rental that doesn't have a permit, we send 2 letters. Occasionally we'll send more, like sometimes they come back, the wrong address or whatever, but standard is 2 letters. First one is, hey, you have a short-term rental, you need a
3
permit.
letters to this individual.
The second one is, hey, we told you you need a permit, you need to get one, or we can take you to court. And then after that is usually the court information.
Right. So are we in the process on this one to do that?
Actually, comment on a specific one. I didn't come
Okay,
prepared
yeah.
with that.
But that's the rule. If you get 2 letters, then you're coming to court with us.
Letter
3 is court, right?
Right.
Unless
Typically.
after that second letter they come in and they work on an application, then we stop sending them notices or court proceedings because we're working with them to
Sure.
get the permit going.
Sure.
In this specific instance, I thought it was merely a line sign, a lawn sign that says 5 rentals. We've all driven by it. It's at the corner of Wells Curtis and Westlake Road. I took a picture. I went through the drill of reporting it online. I figured, get rid of the freaking lawn sign. Everybody else has to comply. Come to find out, he's been sent 3 letters. And by the way, this person or the owner lives in Water Street, New York. So, you know, that's some kind of corporate owner. And we haven't done anything. And there's a short-term tenant there this morning.
Well, I don't,
Dumb thing.
it doesn't sound like we haven't done anything. It sounds like we've gone through.
We sent them 3
The-
letters.
the
That-
process,
That's
right?
not what the
No.
code says, John.
I was just gonna say, now
Okay.
follow up. Now, we've sent out the letters.
3 letters.
What's the next step in the process?
Well, I think the challenge, Mike, what are the challenges? So the next step is court.
I
Walk
don't
us-
know,
right.
because I don't have it in front of me.
But if,
Well,
as it's
typically-
described to you, the next step would be court. They have received
Unless
3
he comes
letters.
in and he's working.
Let's say they
with
don't,
On
right, yeah.
application, which is a different system than Granicus.
So-
Granicus does the flagging, sends the letters, keeps the information, but we didn't pay for their permitting, so we still do all the short-term rental permitting without permit. I don't know if he's working on a permit application right now.
So
Well, let's assume that he is now.
If he's not, then yes, Kristen and Tammy started working with code enforcement office, start discussing work.
Okay.
And he's in violation with a sign.
That's something that we've been talking about.
Well, no, that was in the code that you couldn't have, that we could not advertise.
Absolutely.
Right, it's
Right.
temporary signs, and honestly, yeah, we haven't really been working on enforcing those, because the priority is to get them permits
Our
first.
code doesn't differentiate between temporary
No,
signs.
it
No
doesn't.
signs will be allowed.
And we had that so that if all these short-term rentals up and down Westlake Road all put signs out, that, I mean, that doesn't look that good as a community.
Yeah,
So it sounds to me like it's in the queue. It's been, the owner has been put on notice. And the process sounds like it's working so far. We just need to go and continue to the next step, sounds like.
how long does it take, Mike? Say you have these, say the person did not,
Say it's in the queue.
is not permitted. How long does it take to get a court date?
That's the first one.
Months,
Months.
Because I have-
Take 9 months.
Okay, go ahead.
so months, because we have to prioritize, right? So in order to go through, there's 3 court sessions a month, right, held by this current suit judiciary. Out of those, usually only 1 is available for codes. Reason being is you have bench trials, you have the trap clause nights, those are unavailable to us. We also then have to coordinate with our attorney, right? We are able to represent the town solely as code enforcement without attorney representation, but it's always been the policy of the town to have attorney representation. So we gotta schedule with 2 different entities, right?
but you have to send the letter first, right, and then they have
Yep.
time to.
So
Well, we're assuming that they don't do anything and now it's taking up for it.
we're able to go through and put a court date, then we can start working on appearance ticket drafting and drafting case briefs. The issue with short-term rentals is there's no real physical evidence aside from a listing, right? So we have to tie that listing directly to that property because it's been appealed in court and won that a photo on Airbnb's website does not dictate enough probable cause to say that that's operating as a short-term rental. Because I could find a house that's identical in a different jurisdiction and like that. So those are some of the challenges. Generally, it takes a while to draft all legal documentation because of the amount of detail that has to go into it. I'll be honest with you. My previous municipality, as well as most of the municipalities I know, they have attorneys draft all. We don't. We've gone through and we drafted all ourselves. Some of these case briefs could be 10 pages, some of them I've done are 120 pages. Because I have to provide all the evidence and documentation for the judge, and if I leave anything out. It's a longer process to get that put back in front of the judge.
So do we start fining after the 3rd letter?
We do
If an
not.
unpermitted place?
We do not issue fines, and
No,
that's.
no, I
something that's-
understand that, but we could certainly,
No,
why not?
the judge is the one that issues the fines. If the
But-
judge decides to go back and say, we're gonna start at this date, then that's up to the judge. We have no say on that, aside from my gold standard statement, as well as our attorneys, that we do not seek, any monetary fines. We seek resolution and compliance with the.
But monetary fines brings you to resolution typically. When you start to see that adding up day by day by day by day, then people get a little bit more interested in responding to our.
And that's up
Response.
to the judge. We can't issue fines. We always go through, we say, Your Honor, we can go through, you can decide that you were gonna issue fines in excess of $500 up to $1,000 per day of this continued violation. But the town's stance has always been that we seek compliance.
So we can't issue fines or we choose not to issue fines.
We can't issue fines.
So.
Well,
Wait a
we're
minute.
talking
We've got a
semantics here.
statute, for Christ's sake.
So so we're talking semantics here a little bit. We, by statute, you are 100% correct. We have that in the law that we can find.
Mhm.
Our
No,
policy,
we not can.
We will.
We will.
our policy has been, the fine is there as the stick. And we're trying to get them to carrot. And the judges know that our desire is compliance over the fines. However, with the amount of time that these things take up and the amount of hours that we're spending drafting court cases, drafting documents, doing research, all of everything, is it in our best interest as a town and as a board to change our stance pertaining to short-term rentals and say, you know what, we're gonna, for, you're building something, you have something going on in a project, code enforcement. Yeah, we want to get you to compliance. That's our ultimate goal. But for short-term rentals, do we want to take it to the point of, you know what? After the third letter, we have fines, we make it known to the judge. And I'm sure the judges don't issue fines because they kind of know that that's our stance, that we haven't done that traditionally. I don't know how long that's gone back, but probably a while. Maybe with our attorney, with our code enforcement, and talk to the judges and let them know and say, listen, the era of let's get you to compliance is over. Now for these repeat offenders, it's we will fine you, and the fines are our method to recoup our costs and the time and the effort that goes into it.
So in response to that, I have two questions. Have we ever taken one of these short-term rentals for?
So we have had over 50 court sessions. I do not
Say
have
that again, please.
over 50 court sessions. That's 50 cases, over 50 cases.
On the short-term rental?
Correct.
In what time period?
So I'm the only code officer that's done enforcement on it, and this law's been enacted since before I was
So a couple years?
within a year.
So in the last, since
We
we,
had 50 court cases in the last year.
Yes.
How many
The
fines?
thought that there's nothing getting done is just not true.
yeah,
Because again, and I want to preface when I say no fines, out of those 50.
Yeah.
We had one
That
that
was
did not
fine?
show up. No, that did not show up.
Okay,
The other, again, it's over 50, between 50 and 60.
so let's use 50 as a.
We'll say 50. The other 49 came in, and this is how it works with most of the judges I've ever worked with. Okay, it's on my radar. I'm gonna give you 30 days to come into compliance. You're gonna work with the town. If you don't, then we're gonna go through and we're gonna start the fines from today, because that's when it's on the judge's bench. That's when they have control. They can go through and they can backdate the fines to that date. All right?
But we as a municipality could put those fines on now for the judge to look at and say 30 days, come into compliance, all fines go away.
Take that out because we can't issue fines. It's
So let-
100% up to the.
Let me follow up with that.
Yep.
Of the 49 cases that people showed up at over the last year, what success have we had getting those 49 people to register?
100%.
Okay, good.
So the current numbers that I know Jared was discussing earlier.
And Kim sent, or
We
sorry.
currently have a total of 100 identified short-term rentals, and that number went up, I think, 2 or 3 over the weekend from our software. Out of those, 80 of them have permits. Total non-compliant is 20. Out of that 20, 9 of them currently have applications in review.
Okay.
Only 11 do not have applications.
Would
Now, out of those.
would this be one of the 11?
Yes, out of those 11, only 4 of them are eligible for court. Reason being is because most of those were in the season of rentals. They just went through and posted within the last month. So they haven't even gotten a second notice, let alone court summons.
So they're in process.
They're in process.
And as well as this.
Correct.
And during that in-process time, when they're working with Kristen to get a permit, we do ask them to remove the listing until they get the permit in place.
So, again, I'm a layperson here and I don't mean to speak for everyone, but it sounds to me like we have a process. The process is working. Albeit maybe not as quickly as some of us would like to see it happen. But we do have a process, it is working, and it sounds like for 49 residences, it has been very successful. So
I would agree.
it doesn't sound to me like we need to change anything. But I understand your concern, Tom, that it's not happening quickly enough and fast enough. This one seems to have been in the queue since September.
Yeah, that should be a no-brainer.
Take more staff.
Pardon?
To give it. We'll take more staff if we want to give it.
I think we should boost our fee so that we can afford to do enforcement.
Well, let's revisit this at our next ordinance committee meeting and just see if there's any update that you can give us. And yeah. And I
One of the
understand-
things that you brought up was, these are, this place just south of Wells Curtis Road, right, on the west side of the road. Sign they have there, it's not legal.
That's my
You
point.
tell them to take that sign down.
We have,
Can
They
we
have-
go,
yeah,
can we go?
Why don't we
we
go
have-
grab it?
yeah, well, cause I can't go on private.
I don't think that's.
No, it's not.
It's seen on such a.
To be honest with you, it's 100% clarity out there, and you guys know that.
Is it in the right of way?
It is not.
No, it's not.
I have gone with certain applications that we have, and it is not. We do have it within our code that we can. I would not go through and put that on myself.
It's in our code that we can remove the signs.
It's in our code that we can go and remove the Big Lots sign that I've been asking to get down for a month, 2 months. But I don't even want to test those waters because that's trespassing and that never worked.
Yeah. Doesn't usually end well.
So
Well, what good is it then if we have that in there?
it's been in our
Or-
sign code. for-
Absolutely, that's what my point is, Terry.
So it's been in our sign code since.
You gotta remember too that just because we have something in code doesn't mean that there hasn't been case law establishing other rules about that.
So
So
why doesn't our attorney alert us to that?
Yeah, why bother having code?
What's his opinion on it? Have you
Well,
asked
our
him?
law is our
To
law until
answer-
someone sues us. I mean, we enforce our laws.
Have you asked
I
him
understand, but
why he approves it?
I'm
when
not
John,
saying you get good signs.
and that's
trust me, I
when
know.
John says there was case law, there was recently a case in Monroe County where a code officer entered private property on the bounds of the law. And he was charged with criminal trespassing. I don't.
That's not my, that's not
So
my-
this is an instance where we should be able to fine for that. I mean, we asked you to take that down.
so we want our staff to get charged with.
No, I-
If you're within the law and within our statute, absolutely.
Our law doesn't supersede New York state law.
But until we're sued, it's our law.
Point I was trying to make is why do we have it in there if it's not something that's legal?
Well, I'm
Absolutely.
sure we could hire somebody, an attorney to read through every word of our codes and get all the old stuff out and, you know, go through all the case law and determine what each section isn't relevant anymore or what sections are superseded by state law or case law. When you're even looking at the New York State penal law, there's, just because it's written down doesn't make it black and white. There are hours and hours and hours of case law drafts and decisions that are made outside of those, the words of those laws that become the law essentially. And, or, so you have your law that you can technically enforce, but then all you're doing is creating lots of time and money just for a judge to throw it right out because there was already a decision that was made that said this, and that's what needs to be followed. There's a lot more that goes into it than what just reading what's on paper.
Our short-term rental law was recently updated, as we all know. So that was reviewed by Chris before we actually went ahead with it and approved it. So if there is something in there that's not legal,
To
it should have
clarify,
been removed.
with the removing of the signs.
We're
from our
talking-
generic
No, I mean,
sign code. It's not
That
from
part
our
of the
short
code
code.
should be removed. My point.
And we can bring it up to him, we can bring it up to ordinance here and have it removed, it's, but to John's point.
Well, I mean, if we can't enforce it.
We
what's
have
the
a
point
lot.
Having it.
I'll be honest with you, there's a lot of code that probably needs to be reviewed and hasn't been in years.
We
try
spent
to-
years
So,
This is,
reviewing this.
Let's try to rail this in. I know it's an emotional topic for many of us. Because it's just like Tom's saying, we've been dealing with it for 5 years. it doesn't sound to me like there's a problem necessarily with the ordinance or the code. It sounds to me like, we are enforcing it. I mean, to have 50 notices go out and have 49 responded to in the last year, I think is pretty indicative of the hard work that people are putting in to try to make this work for everyone. So it sounds like this one in particular is in the queue and it's in the process. And I think for the sake of everyone's temperament, I think that we ought to just let the process play out for the next month or two, and let's review it at next month's meeting and see if we have any update. And it sounds like it's an issue with enforcement and the process rather than how the ordinance is written. And the purview of this committee is not necessarily the enforcement. It is making sure that the codes are in place and that the townspeople have some ordinances to follow and work with, so.
I would ask that over that next month, and our attorney take a look at this and tell us what's legal and illegal in it.
There is something we can do too, like on the permitting side. I mean, when we're issuing a permit for short-term rental, you know, the most important things is the house safe, you know. Kristen works with Mike's office to make sure that a code enforcement officer goes through the residents and make sure everything's safe before we give them a permit. We make sure we have floor plans, we make sure they have insurance that allows them to rent it. But we probably don't talk about the signs because we make them sign off and say, I have read the law and I agree to comply with all parts of the law. And we ask that they sign that. But we don't walk through the entire law with them. So it's really on them. But we could put in a note as a reminder, hey, please don't put a sign out.
Yep.
I mean, I
I
don't
think
know
that's
if that
good.
would do it. I don't know if that would fix it, but we could
Can't
really
hurt.
try and remember to do that.
Yeah, can't hurt. Okay. That's
And we've, and also with all this, we're dealing with like everything in life. The 5% or the 2% that takes up 95% of the time, unfortunately.
the 80-20 rule.
And I won't drag this out, but I'd like to meet with you and Mike afterwards in regard to the other one that I think is an egregious violation. And you guys are absolutely nuts for ignoring it.
So,
Absolutely.
You good with that, Mike?
yes,
Okay.
for the benefit of the people that weren't at the last board meeting, let me explain why manufactured homes are back on the agenda. We thought we had it resolved, and I think that the majority of the board thinks we have it resolved. However, I do think there was a pertinent point that was raised at the board meeting, and that's why I asked them to table this. And until today, when we talk about it. And that was the lack of a definition for a foundation, right? That's kind of, in my mind, what got us back here to the table today and bring this issue back to the table today. And Mike, can you kind of follow up on what I've said there and just kind of explain?
Yeah, so Kim, can you look at that presentation? So I passed out a presentation that I drafted. I just got back from vacation. It's my first day back, so I apologize. I kind of just created a presentation to go over the entire law amendment.
We don't have it on
I should have gotten
This right here.
this here?
Yep, correct. So this is a generic going over every aspect of this code and the amendments that are being proposed. So first slide is an examination of the old law versus the new law. Again, I really wanted to just go over it because I didn't know exactly what specifics. So I apologize, but basically the old law and the new law, there's some, the biggest thing is the exclusion from the RLD zoning district. There is currently a 20-foot width requirement. And I put down the entire section there about shall be sited on a full perimeter foundation. With concrete or concrete block foundation walls, extend yada yada. All right.
Can we just pause there for a second? What's the difference between that bullet and a bullet for the new?
So we condensed that whole sentence into just shall be sited on a permanent foundation.
So would it be more enforceable and clarify the difference between a mobile home and a manufactured home?
So
That's already defined.
that's already, yeah, that's defined within our law. I've got the definitions followed up for those. If you, I can come back to that if you don't mind.
Could I just ask Mike we don't have a definition of a permanent foundation?
We do not.
Could this be the definition of
It could.
permanent foundation? No.
And I'll show you some examples that I got at the end of the docket. Let me just see, I thought I had it in here. Even a foundation is not defined within New York State code. Also, that's the big one that I forgot to put the star note on here. So next slide is why are these changes necessary? It goes into the case law that John referenced, previous meetings regarding executive law from the state. There's a snippet in the quotation there, basically, in short, it says that a manufactured home affixed to a permanent foundation is as such a single family home and cannot be governed. Basically, what that means is that if you define it for a manufactured home, those requirements have to be the same for all single family homes. Otherwise, it's unconstitutional. The case law for that is referenced in bullet item 3. Town of versus Parker in 2018. That case goes on to include issues on roof slope and building materials and other items as far as that. There's a link I can send out to a full brief from New York State on that case, as well as some other stuff. As of August of 2024, which was the latest that I could find, no New York State court has interpreted what a permanent foundation is. Now, for codes, what does that tell me? It's not defined in New York State code. It's not defined in our local municipal code. The way that we go through and work on definitions is we then go to Merriam-Webster's dictionary. And that's where we end up. So the term permanent is just defined as shall require excess process to remove. It's basically one of those where yes, you can remove it, but it's gonna take work. That's kind of the short layman's term definition for permanent. Next slide, we're gonna get into the definitions.
Could we define it ourselves though?
We don't.
No, I said, could we?
Could we? We could, but I think it would be a struggle because of how many foundation types there are.
Well, let me ask you this question, before this came up. So, mobile home, for lack of a better word, on a slab with skirting around it, is that a permanent foundation?
Yes. And I'll show you why. I got those.
No, I'm
Yeah,
pretty sure I knew the answer.
I got it. So it is. We'll skip over the definitions. You had a question, Doug? It was a similar.
What if we defined that a foundation has to be engineered?
So that's already a part of the manufactured home code that it has to be engineered. Reason for that is you have to have tie downs, you gotta have piers. You actually, even outside of flooding limits, you have to have some sort of flood.
So wouldn't that be create more of a restriction for someone taking I'm gonna call it a mobile home and putting a mobile home on a foundation? Because they'd have to go on. They'd have to have created engineered drawings, right?
No, most of them are built in with the actual unit. Most of the plans that we see, I'll be honest with
On
you.
manufactured.
Well, so we don't do mobile homes anymore. I gotta remind you that.
Well, that is, I think, Dave's
Mobile homes
concern
are no more.
was that the definition is no more mobile home.
I'll show you that.
New York State changed,
So
but
if
that's
you
New York
can-
State changing the
Manufactured home,
definition.
what they call it.
But in practicality, let's talk about that, because that's, I thought was Dave's concern. And was that someone could take what we used to call a mobile home and site it on a piece of property in the residential lake district. And it came up that, well, we wanted them to have a foundation, a permanent foundation, and we thought that that would restrict someone from taking a mobile home.
You mean one manufactured before 1976?
Not necessarily,
That's a mobile home.
That's the definition for mobile.
Mobile home, right?
but I'm talking about impracticality here, and I understand the definition,
So you
but
mean a manufactured home?
A manufactured
No,
home that
no,
comes in on
I'm gonna-
axles, the
I'm gonna
axles stay there
differentiate.
and you put it on some site.
That's
what we're talking
manufactured.
let me differentiate,
Right.
okay? Mobile home to me is what is down on the corner of East Lake Road and Lake Shore Boulevard.
Manufactured home, unless
To
it's
me,
older, then it's.
Those are mobile homes. Because they have a tongue on them, people put them on a temporary foundation typically,
So those are all permanent foundations.
okay,
I got some photos of those, I'm sure.
engineered.
Yes. Yep, I actually just permitted 5 brand new ones that are.
Okay, so then the permanent foundation is not restrictive then. And they could do it with a mobile home or a manufactured.
With a manufacturer. And I only say that because of the definition, I apologize, but I gotta be kind of clear on that just for my
The
own.
In
definition
my
now
office
doesn't
too, will
differentiate
not
between
deter
the
from
two.
property.
It does purely just based off the date.
Yeah.
Mobile homes weren't necessarily underneath HUD. Now all manufactured homes, and that's the current definition of the term, are not only licensed by HUD, but also by New York State Department of State. They're constructed under the supervision of both HUD and New York State. To the point where, to be honest with you, the plans that I got from Cook for those new manufactured homes that is permitted, they have stamps from, I think it's 30 different states. Engineer stamps from 30 different states, because the engineer drawings are so generic that it says, for this soil classification, you're gonna do option A. If you have soil classification B, you're gonna do option B. So it's really just piecemeal.
It's engineered.
It's engineered.
So I guess in response to that, does that change our ideas or thoughts about whether we want to have manufactured homes in the RLD?
Cannot.
Problem is,
Well, we can't
we
differentiate it.
can't because we'd be in
Can't.
violation of state of.
And New York State, we can't supersede New York State law. If somebody wanted to put one in right now, they can do it. We can't tell them no.
And if we said no, we'd have a massive lawsuit.
We couldn't,
Against
we
us.
can't say no.
Well, not
It
just
wouldn't even be a
the
lawsuit.
RLD,
You
Jim.
cannot,
They're allowed every place.
They're allowed it currently.
The only place they're not is the RLD.
Mhm.
So why should the RLD be any different than the rest of our
And that's-
town?
And that's.
this was
Yeah.
confirmed
That's
at
the-
the training that Sarah
However-
was at.
The basic question, do we want them like that? No.
This was just confirmed at a training that Sarah was at, the experts there that said, somebody wanna do it, they can come in and do it.
Yeah.
And we cannot tell them no.
It was
It cannot be done. There's no lawsuit or anything because we can't say no unless we physically stop them from doing it, which will be a whole nother issue. We can't prevent them from doing it.
So let me ask the follow-up, which is motivated by Terry's question. Can we legislate against having manufactured homes in our community?
No,
No.
entirely illegal.
That's a big.
So
the left, we're talking about this.
Right.
It's
Absolutely.
So the reason why is because currently our current law is non-compliant with New York State.
So then it's a no-brainer. We just have,
It's a no-brainer.
it just has to be done.
It has to be done.
Otherwise, we're out of compliance. Now, the other hangup, and I hate keeping coming back to this, but I'm going to. A lot of our semantics are getting in the way with this too. Because, we say mobile home and manufactured home, in my mind, the date differentiates the two, but they're the same thing. Then you have the modular home. And sometimes modular home gets convoluted with mobile home, but a modular home is different. Okay, so so you have modular home and you have manufactured home.
We're all manufactured.
Right, but
Yeah.
modular is different than the manufactured.
Let me help.
So right, huh?
Tell me how.
That's in your definitions.
That's in the definition, but from my lay perspective, manufactured homes are governed by HUD. Correct? Correct. And nationwide rules and regulations. A modular home, if I come in and I have Key Modular Home come in, not to be propping Key Modular Homes, but if I have a modular home company come in and set down a modular home on my property, Mike is coming in to inspect it. Am I correct?
So I'm inspecting everything. That's one thing I gotta be clear on. We inspect manufactured mobile modular. Modulars are not licensed by HUD, though. They are only licensed by New York State Department of State. Jared's correct in the sense that we do not inspect it like a house where I'm inspecting framing, installation, plumbing. It's showing up and the code spells out exactly what I need to look at, and it is connection points, utility connections, appliance connections, general testing of the plumbing system and stuff like that, as well as the electric. And the connections between the foundation and structure. Aside from that, I don't open up any walls and I'm barred from it. So our inspections go from about 40 inspections, rounded number, for a stick-built home to about 10, and that's why we only charge $400 for the permit.
That would allow us to hire somebody to enforce the short-term rentals if we did
But-
400,000.
That's why you have to remember from our fee schedule, we drop the fee significantly for manufactured and modular, because we're not
Yeah,
doing
it's
it.
not-
Yeah,
But New York State doesn't say, I mean, from a square footage standpoint. We could, whatever, however you wanna call these modular homes or whatever they are. If we didn't decrease our square footage, we wouldn't have this problem right now. We wouldn't be having this discussion right now.
It will, I guess.
Well,
clarify.
most of the things that you would consider that come in on an axle and the axle stays there are not 1,100 square feet.
So manufactured, no, manufactured homes by New York State definition is 320 square feet.
So the mobile portion of manufactured home, they still have the wheels underneath them.
But that's,
Most
it's,
times not,
No,
no, I'll be honest, they're gonna use the wheels on a different one,
they take the
The
wheels off,
axle,
the
yeah.
axle stay,
the chassis is still.
the chassis
Yes.
is still there,
Chassis,
and the tongue is still sticking out.
correct.
sometimes, so it really depends on the foundation that's constructed. Most times it's never sticking out anymore, because the tongue is actually underneath the flooring joist.
They use that to tie it down to the permanent
Sometimes.
foundation.
I've got some photos of below foundation in the rear of this slide packet that show actually a tongue being tied into the chassis. And it all gets used as structural. So,
and that's the real difference is that prior to that date, you would see the tongue.
correct.
And you would have like something planted, something planted around it.
30 has a really good example.
Short Road and 30,
Correct.
that old grape, the old Washburn place at the end. That you see the tongue right there. And
That's a mobile home from the 60s.
right, so that and that
You can
and
still call it mobile.
That you can.
that you can, Terry.
Yes, sir.
So we want both of you to say mobile home on Short Road.
With pride.
Let me step in here to summarize. It sounds to me like the ordinance that came before the board last meeting needs to be passed so that we come into compliance with New York State.
Correct.
The follow-up question that Dave just raised is, do we have any appetite for going back and modifying the minimum size of homes?
So I
Even
would say,
if
you
you
know.
did, we'd still have to permit a single wide manufactured home for being placed, because even if our code says it has to be larger and it's smaller, it doesn't matter. From what I learned on Friday, they could still place it in the zoning office.
There's
would allow
case
it.
law that supports that.
Yes, from 2015, the executive law.
Aside from
Then, that being said,
Good, but why?
we could, but why?
And then I'll mess up ADUs, which is our next conversation.
Whatever.
I'll throw that right in the trash.
So it sounds to me, in summary, before we spend any more valuable time on this, we have to pass the ordinance to come into compliance with New York State. And it sounds like whether we have an appetite or don't have an appetite for the size, minimum square footage, it's not gonna make any difference relative to manufactured homes.
Non-manufactured homes, it would just then restrict someone who wants to do a site-built house that was small.
Okay, so that all being said, do we have any desire to continue conversing about this?
No.
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 I don't either.
It's gonna put so much time on this job.
You guys should.
I appreciate that very much.
No, it's very good. I was
Hey,
looking
just
at
one
it. Yeah.
question. How many,
Nice job.
so you said you just approved 5 for down at the mobile, the manufactured home park. Outside of that manufactured home park. Are people coming in wanting to cite one of these in other zoning districts?
Yeah, so I can tell you, I've permitted and completed 3 to outside manufacturing home parks in my tenure. And we do get a lot of questions on it. The biggest thing is the single wide.
Yeah,
So people really want to do a single wide versus a double wide, because I got the information in the slideshow. Single wide median price is 85,000, and that's the purchase price. Whereas a double wide is 155,000. So
No.
A lot of people are going through and they're saying, hey, I'm retired, I really wanna move back into the area, spend time with my kids and grandkids. But I don't wanna spend what's gonna amount to 300,000 when you get site work and permitting and everything else in. I just wanna do 200,000.
But lot size stays the same, minimum lot size.
All that.
All our zoning stays the same, it's just going through a drop. And there's a lot of good examples on manufactured homes and what they look like now in here, including ones in town. So,
Well, I appreciate that. Thank you for that hard work, but it sounds like we're ready to move on.
The ones that you have, the three that you talked about, what kind of foundation is just,
so that
you have
is,
pictures in your,
yeah, if you go to the first picture, that is currently one that was permitted.
the first picture?
Yep.
Well, you're looking for
Kim's
that.
got it up on the.
Murph, you've got the New York State definition of manufactured and modular homes and our definition.
Yep.
Are you saying that our definition should be brought up to code?
No, they're
Okay.
the same. So I just wanted to.
I didn't sit and read them, but I
Yeah,
just
they're-
see you
they're
had
the
the
same.
two.
That's single one.
That's a double one,
A double.
because we didn't allow. You don't
This is
allow-
the interior of it, then.
That's not, that's a generic
Different
one that
one.
I just found. That was actually done on, I believe that was Kuka.
Okay, so this is a double wide,
That's a double wide, yes.
but it's on a permanent
It's not a
foundation.
permanent foundation.
I mean, it's
Yep.
block down
Yeah.
below.
The biggest thing is that's not a foundation that extends below the frost line. So technically, I violated our own town ordinance by permitting this. I'm sorry. Because the new thing now is shallow frost-free foundations. You don't have to go down 44 inches. 42. 42, 44. You can go through, you go down 8 inches, you provide insulation. I have the foundation diagrams on the last 2 pages for everyone that show these new types of foundations. And you're able to go through and construct these with minimal excavation, minimal concrete, minimal block. And you're still providing the same insulation and weather resistance that you would on a home foundation. So,
How easy would it be to move one of these manufactured homes that come in on trailer after the fact, if you say, I wanna hook onto that tongue and yank it out of it?
it's gonna take some work, cause they have to be anchored down. The photos below below the structure within the foundation, you'll see connection points galore, tie downs that are on piers, or they're not permanently attached to the piers.
Just got the photos up.
But it's a lot of work. So, and you can see there's the tongue that's concealed within the foundation. So,
Let's move on. Unless anyone has any other comments.
One other thing, you said you were off last week,
that's two.
that's 2
Yes,
weeks.
sir.
So you created this between the
this.
time you came in this morning in the meeting?
I created this 2 hours after your guys' board meeting, so before I left.
That's proactive.
Thank you.
Thank
So-
you. It's very interesting.
We will, so everybody's prepared, we will need, that resolution has to be acted on.
Yeah.
And if we vote against it, we're out of compliance with state
Remember
law.
this conversation, please. Some,
Yes. Okay, let's talk about ADUs. What do we need to talk about as far as the ADU law?
I think we just, I mean, we did the final draft, I think it was just, going through the final draft one last time to confirm that we're good with it.
Chris Nemmer.
Nammer needs to look at it and we have one major problem with it.
Oh,
It's the one I keep telling you guys
All the one we
about.
talked about, that's right.
Right now, the law as written requires a detached ADU to be exactly 720 feet, no larger, no smaller. That's it. That's the only size you're allowing with your law.
So
And
that's,
that's.
Yeah, so we
that's
need-
another-
You need to just
Not to exceed.
figure out another way to write it, so I need to pull it up.
Which is made
It's
minimum
just
seven.
said or less, shall be a maximum of 100%, or what was it? Yeah, of the existing home, or 720 square feet, whichever is less, but our code requires things to be no smaller than 720 square feet. So it's just the way the language is written. So you can't can't write it that way, so
So
you leave it
minimum of
inside
120 or maximum of the existing house.
or 720 square feet, whichever is less.
So,
So it's written so that if the, sorry, let me pull it up.
720
I got
is
ahead of
probably
myself.
always going to be less than the existing home.
Yeah, let me ask you this question, if it's just simply
That is,
Semantics.
verbal
Semantics.
or how it's written,
It
does
doesn't
this
really
group
impact
here
the
need to spend
discussion.
any time talking?
well, so I think we just need to confirm, because I recall that the intent was to allow the home to, for the ADU to be up to the size of the primary structure, correct?
Yes,
Yes,
So, yeah, so then,
and no less than 7.
but a minimum
No,
of
listen,
720 square
so if
feet.
that's the case, then we really do just have to deal with the wording. And I
yeah, so it'd be
think there was,
whichever is less would be whichever is more, the greater.
So we're talking about item,
Why do we say more and greater?
Before-
Why don't we just say
Yeah,
it
just-
has to be between 100% of the house and 720, which is our existing code?
you can work on the language and bring it back to us.
yeah.
Well, we want to act on it at our next board meeting.
I'm good with
Yeah,
that
we'll
too.
get, we'll get it there.
That just
Um,
have the gist of that, what Dave said.
Yeah.
I just wanted to confirm that that's, because that's what we determined was up to the size of the home, and then also, I think there was just one other question. And only because we have a recent example of somebody who's actually asking for this is what, we want to do is, and I don't recall specifically the conversation on whether we would allow larger, if if somebody wants to come in and build the house larger in the rear and then make the front the
Yeah,
ADU. So I think we have it in here, it has to be,
yeah, that the ADU has to be behind the main house. So the example is, I had a resident come in and she has 5 or 6 acres. And her house is close to the road. Her kids want to build a house on some of the area in the back of her lot, but they want to build a house larger than hers. Which, if we're looking at the way this is written, it kind of says, oh, well, then the existing house will become the ADU because the second home is gonna be larger, but the way it's written, it doesn't permit the smaller, the ADU, to be in front.
I don't think, from where I come from, and I'll ask everyone else, it doesn't matter to me.
I don't think
Whether,
it really matters.
well, and that's what I recall did not really
I think it's
matter.
relevant.
Why, because we have an actual.
So let me ask you this question, does the zoning board, does the zoning board?
Oh, my goodness.
Does the zoning, I mean, would your example
Yeah.
go to the zoning board? Why,
I suppose if the law were enacted where it says that the ADU can't be in the front, because it already says the ADUs can be same size or smaller. If they're building one bigger in the back, they'd either have to go to the zoning board to allow their ADU to be bigger than the primary house, or they'd have to go to the zoning board to allow the ADU to be in front. It just depends on how the zoning office, how we define.
So we need to take that out. We need to figure out a way to get that out of the
So-
equation to make it easier.
I don't think it makes a difference.
'Cause every
whether the
step-
ADUs in front or the
Yeah, if
back.
you don't care, then maybe we should
I drive
remove
down
that
Westlake Road,
prohibition.
and there are houses
can't
that are
tell what's
smaller,
what.
and then there's houses that are larger right behind them, and I mean, who knows
Yeah.
whether that's on the same lot or not, as you're.
I mean, if we're truly trying to make it more flexible for landowners, to have that second home.
Right.
We have other rules in place to, that it's just going to
lot
be a
coverage
home.
and things like that should
Yeah.
come into play.
They would, yeah, and the way it's written, it still has to meet the setbacks for a primary structure, the ADU would. But I mean, we would be doing that anyway to single family home, whether it's an ADU or a primary structure, it's still a house, so it has to meet all the rules, it's just, do you care? If one is smaller and one is bigger, and do you care if the smaller one's in front?
Unless we take review of new homes out of the purview of the planning board, why don't we just put a clause in, which is in many of our statutes, that the planning board can waive requirement? Is that an easy workaround?
No, that'd be-
It's in chapter 220, they can't.
Zoning law.
Yeah, I don't know why we gotta have a workaround, why do we care?
Yeah.
As long as it's 720 square feet,
Why do you care?
I'm front or back, what difference does it make?
Back to that first conversation, the
Agreed.
change you would need to make to fix the first issue I brought up is to remove the statement in 4B where it says, detached accessory dwelling units shall be limited to a maximum of 100% of the total gross floor area of the primary dwelling unit, period. The part you need to take out is or 720 square feet, whichever is less.
Right. Minimum that's.
So then you're allowing ADUs to be up to the same size as the primary structure.
Correct.
But that was where I brought it up. I was like, so
So is it easier,
It's
rather than
easy.
switching
It's an easy.
between the front and the back, is it easier just to put no size limit
restriction,
restriction on the ADU?
it could be because then you could allow, or let's go back to my example, because that's the other thing is I would have to tell this person no, because it can't be any bigger than the existing structure and the way our law is written, it's assuming the ADU doesn't already exist. So whatever they're proposing has to be the ADU.
Yeah, so they can't, so it's,
So that would still have to get a variance unless we remove
yeah,
that.
because they couldn't start building it.
Because the existing
Knowing
already
that they,
doesn't have a
yeah, the
C of O.
existing home is still that first home until they complete the other one, so it'd still be the same size.
To me,
So
and I've heard the word used a lot here this morning as far as semantics. I think you should draft the language. And I think that the concept here is that we want to be flexible. And if someone wants to build the primary structure after the small ADU is already on site, so be it. I don't think we want to restrict that.
So what, can I just,
Take out 4B.
can I just ask a question? Do we just go through and repeal and say instead of only one single family dwelling unit on the lot, you're now allowed two?
It would be much easier.
That's what you're doing.
I mean, instead of going through and piecemealing this whole thing, we
Well-
keep the law how we have it.
There is other language in here about driveways and
Electrical
utilities
too,
Yeah.
and
Yeah.
like,
you wanna
that this is
control that.
still one lot, it just happens to have another single family home on it, but not like two whole separate driveways and all that. So I mean, I think there's still valuable language in here.
So to accomplish that, we basically just gotta remove the maximum restriction on ADUs.
Are we okay with with removing the maximum size restriction?
Well, we still have size restrictions on attached dwelling units.
Right.
So the ADUs that are
The
But-
atta- and that
Accessory
stays the
apartment.
same.
The detached,
detached would just fall to open area requirements of the underlying zoning district.
Great.
Okay. I could
The easy fix is just
Attached.
Eliminating
Situation.
the maximum size.
Yeah, that's the easier way.
That's the easier one.
Attached,
I have.
what you're talking about, someone wants to build a larger,
Yeah, so that's the detached.
so that they would be attached though, so.
No,
No,
we're only talking about detached, the attached.
we
Attached.
already
Yeah, but-
allow the attached. This is, so the language for the attached hasn't been proposed to change.
No.
Just detached.
Go ahead, Chuck.
So John, on your property, you've got enough room in the back. You could build a house the same size as your current house in the back as an ADU.
Or one that's larger.
Right.
Well, if you make the front one near ADU.
And then you got two
Okay,
houses
I'm-
on one lot, so.
Trust me, Chuck. Not in my wildest dreams. I want to build a house larger than mine on my existing property.
Your son said he wanted. That's
Yeah.
Maybe
not what
not
Johnny
you,
said.
but somebody else.
Yeah, but you're right. You'd have two dwelling units on.
That's essentially what this would.
Yeah. Your line.
it would allow that, but they
It would
would.
allow a small ADU, 720 square feet, or up to a second house on your.
Same size.
With the restrictions that it's not a separate parcel. Because I know that what we don't wanna have happen. And I can hear Tom, I'm gonna speak for you, if that's okay, we don't want these. To be there, and how do we prevent them from being there for a year and then turning into a short-term rental?
You gotta deal with that in your STR law.
Yes.
There are
Cause that,
ways
we don't
you
want
can
that to
restrict
happen,
it.
cause that's gonna defeat the whole purpose. No,
That are.
that's gonna defeat the purpose though, the purpose of the
But how do you
ADU.
prevent that?
One quick comment on that, and I've mentioned this before, is it seems like our short-term rental law is at least due for a conversation in this committee, right? One of the things that you can do, and I think I've shared examples from other communities, is if they have a lot with more than one house on it, you can restrict your short-term rental law so that you can't have more than one short-term rental if there's more than one single-family home on the property. one of the other things we mentioned in here, I think our language says that, the property owner of record must reside in one or the other, the primary structure or the.
I think that would
ADU.
help restrict some of somebody buying up a
would-
corporate or something.
So, I mean, that kind of does it in this law, but yes, you can do other things in the short-term rental law. There's other communities that have a range of examples of how they restrict it from getting to,
I think that just having one short-term rental per property would address that pretty,
Yeah, and right now,
It's the
there's
first step.
nothing in our short-term rental
Right.
law that says that.
right,
Because if you did that in
So-
resident owner,
right,
then that would eliminate a lot of the issues.
eliminate renting out both houses.
To summarize now,
Mhm.
because it sounds like we're all kind of in agreement. We don't care whether the second unit is larger than, as long as it's not smaller than 720. And we're gonna modify the STR to say we can, only one of those structures can be used as a short-term rental.
One structure per property that would be
One
used
structure per
as a short-term rental.
Will say that if you want us to bring that to you, that will remove some licenses
Mhm.
for short-term rentals. We do have at least 10 properties that have multiple structures permitted on those properties.
Let them go to the zoning
Multiple
board.
short-term rentals.
Correct.
Yeah, on one tax map number.
So can we
But
say,
it's a big lot. That's the one I'm thinking of.
Local.
Is this one in the city and the town both, the one you're talking about?
No,
It's right on
we
the
have
edge.
like at least 10.
Okay.
No, that one, he has one on each side of the,
so that begs the question,
Okay, that's right.
whether we care whether a person has more than one short-term rental on a property.
Yeah, I would say we do. I do,
We do care.
yeah. What do you want to create
Yeah, I think,
So
a
then,
motel?
that being the case, then do we want to set, what do you call it? The other properties are already, existing, grandfathered, they're
Yeah,
not
that's
conforming.
what, yeah.
And then anything from the future forward?
Mike's shaking his
I
head.
don't think you can do
The
that.
reason
yeah.
being is because it's a special use permit with an expiration date, so once their special use permit expires, they have to come into compliance.
and the short-term rental permits for those that don't require short-term, especially. So some. The short-term rental permits are only good for 1 year, so when it expires, even if we let them
Sorry, not the special.
grandfathered in, when that expires, then they have to apply for a new one, and then we would apply the new law, and we say, nope, sorry, this time you only get one.
So Mike, those 10 properties that you're thinking about, are any of them owner live on the property?
Yeah. Yeah.
Do most owners live on the property? That's another way around it.
Do all.
Well, so that's the thing, sometimes they do, sometimes they don't. The one I'm thinking of, the property owner lives in the main house, but sometimes rents out the main house and the spare house. And they go away, I don't know where to.
But I think what we're getting at is we don't want corporate buyout of all of these
Yeah.
and some. Hedge fund somewhere managing or some whatever managing 10, 15 parcels.
Yeah, that's what that.
In the
would
town.
prevent, because quite frankly, to try to enforce somebody who, goes away for 4 months. And then rents their main home, it's not gonna be enforceable. So
No.
that would be the intent of doing that would have to be simply to avoid corporate buyout. Because it shouldn't be expected that code enforcement is like knocking on doors, ensuring that the owner is the one at the house.
You good with that, Mike? Doing that knocking?
No,
So
Well, the only way we enforce anyway is by a complaint, so that really wouldn't happen.
it sounds like the challenge is that we have 10 residences approximately that would be impacted if we say that we can only have one short-term rental.
Per
For
property.
tax map
yeah,
parcel,
one dwelling.
Tax map, yeah.
and
And
you
if we-
only allow one accessory dwelling unit per parcel also.
And if we say that we're only gonna have one short-term rental per property and these people's licenses expire at the end of the year or next year, whenever the case may be, then they're being penalized because we don't wanna have multiple short-term rentals on the property.
Yeah, so that's out.
It'd be legal taking, I think.
And
Yeah, but those properties were there before we even had a short-term rental law, so it's not, I don't know.
Yeah, but you're
It would
depriving
be-
the property
Some of them.
owner of,
Right, would-
I mean, I don't think that there are that many properties around that are gonna be adequate to allow more than one or two structures on them to begin with.
As
I
far
know
as.
one at 3814 County Road 16, but aside from that, I mean, I don't think there's that many properties where we have this challenge. Did you say, Ken?
Bruce Main.
Where's that?
it's the Red Barn just before Wegmans.
times two.
On Westlake Road?
Properties there. Yeah, so that example, it's property owner they own, well, he personally owns one lot, a family member owns the other, he manages both. Both lots, one has three, the other one has two. STRs.
And an ADU law, you could put one up behind it.
So there's one property in Old Town.
It's already there.
And then there's another one further down at off of 16 that currently has three.
Yeah.
And then another one that has three or four. There's another one on Seneca Point Road that has two.
Well, let me ask the question, because we cite more examples, but all this being said, do we care whether a property owner has more than one, or more than two homes on their property?
Well, I guess it comes down, to what's the number then, 10 or 50? Is it okay to have 50 of them?
I don't
You
know
have
if we
enough
have,
room.
I don't know if we have that many.
No, I mean,
properties.
well, I'm just, I
It's
don't
the
know.
housing development.
If you do.
You can't play the what if game till it's ultimate, which is ever.
But they can only have one
Never
property,
happened,
right?
but,
Correct.
you know, do you want some big chunk of property being bought up and put 20 of them in there? So you got a big campground right in the middle of a zoning district that we don't want a campground in, you know, I mean, that's, you know, where are the limits here?
So would we be comfortable if we cap it at two?
These,
Might
Two-
be useful to
two
remember.
situations.
why we
Are you talking
want it.
short-term rentals or ADU?
Two
well,
homes on a single lot.
So limited to one accessory dwelling unit.
Which is
One
how it's
accessory
proposed
building.
now.
And that's currently.
Does that work?
I
Now,
think-
that's a discussion separate from the short-term rental.
Right.
That's separate from
That's right.
short-term
I think-
rental. I think we get this done and then we go back.
Go back to the.
Yeah, let's get this done, buttoned, tie this up.
Sounds like ADUs are, we're in agreement on it.
Put a bow on that.
Yeah.
We comfortable with two, Terry?
well, I separating STR and ADU, I think we're talking about ADUs, so set the STR
Right,
aside. The ADU. I mean, really, the discussion is which is smaller, which is larger. You know, you gotta meet all the other parameters, all the air bulk requirements of the lot and all that. Probably doesn't make any
Yeah,
difference.
we wouldn't,
Feel like there's.
On the other side, the examples you're citing of different properties, they have 3 and 2 and all that.
It's a different conversation.
I wasn't aware that they did until right now.
Yeah.
And just.
I drive those areas every single day and I don't see them. So.
We wouldn't have to, just to clarify, we wouldn't have to flip flop now between which is the ADU, which is the primary structure, just by simply removing the maximum.
Yes.
limit.
Right.
So,
And
And that's-
limited to one ADU.
which is what it is, yeah.
Okay.
I think
With a minimum lot size of 720, that's it.
at the outset, this was to build,
Yeah, yeah.
allow
Yeah,
something
yeah.
smaller to be built. I would think that is what most people would want to do.
Mhm.
Not build, gee, I wanna turn my 1,800 square foot house into the ADU and build a 4,000 square foot house behind it. And I just don't think that's ever gonna.
Yeah, no, and this example it just brought up that, you know, to
Oh, yeah.
consider that, well, you know
Right,
what,
'cause-
if it is the, you know, the aging parents that live in the smaller home in the front, and they have all the room in the back for their kids to come in and build a house and take care of their aging parent. Yeah, that's all this brought up was, well, maybe we
The
gotta
intent,
change that.
the intent
Yeah,
remains
so-
the same.
the.
It does.
Yeah.
You gotta put
Are
a,
we good with that then?
Yeah.
put a flip flop clause.
Can I-
in.
Wrap it up.
So-
Yeah, I just wanna, can I just do a follow-up to tell you, because I've got the draft in front of me, so I've been trying to keep up with the conversation to make sure I'm editing the parts that you wanted me to edit. Location of unit, 1D was the one that said it had to go in the front. Now it's edited to say a detached accessory dwelling unit shall meet the setbacks for a principal structure in the respective zoning district of the parcel. That's it.
Yep, and a minimum size of 720.
And then the size for B detached accessory dwelling unit size shall be regulated by bulk and area requirements of the underlying zoning districts for single family homes
Perfect.
or principal structure, however means. I can talk to him about language, but that basically, I think, covers what you guys discussed. It's simplified. The only size restriction doesn't need to be noted because it's already in our code that it can't be smaller than 720. The attached accessory dwelling units, which are the accessory apartments, we didn't change that from how they're written today.
Perfect.
So do we?
That all being said then, I believe that can go to the next board meeting too.
It's already
Yes,
on.
it's on public, it's on for public hearing, so we'll have the final draft set also for resolution to adopt it in the same meeting.
Great.
And just a reminder, there won't be a red line version because this is all new code.
Yep.
The draft that had been circulated had come because it was changing from how it was originally proposed, but it'll just come in this language.
That's good.
For
Tom, go ahead.
clarification, Sarah, so. B for B is deleted altogether.
No,
No,
it's just that talks about the sizes of each. It's just clarifying that B, the size of an detached, I'm sorry. The size of a detached accessory dwelling unit is only going to be regulated by the existing bulk and area requirements of our zoning districts. There are size restrictions on a small lot. You might run out of room
okay,
because you might have a lot size or a lot coverage restriction, so that can come into play. So I think it's worth noting, but yes, effectively, it could be larger than the existing.
thank you.
We good with that? Okay, that's a wrap on that. Now, do we want to go back to short-term rentals?
Do we have to?
Maybe. Is there a concern about short-term rentals now? Do we need to say that only one structure will be a short-term rental?
Well,
Mike, go ahead, shaking your head no.
I would say no, it's not a problem currently. I think it would disenfranchise some.
There's 10 properties that we have to be concerned about.
I don't see an issue with it, just for the sake of the example of the campground. Once you go over 4, I believe it's 4 or 5, then you are classified as a campground, not only underneath our local laws, but as it's also New York State DOH, all that. So I don't foresee it.
out of all the short-term rentals that have registered so far, how many have more than one?
Around
10 out of that 80 or so that have registered so far?
And no complaints on those 10, so
So it sounds like we should leave it alone until we have.
until we have to, yeah, I'm
All
with
properties
that.
that have been around a long time.
Yeah, I'm up with
That
that,
just had
yep.
more than one.
Well, wherever they are, I haven't noticed them.
Right.
Yeah.
And I think the only
Good.
thing bringing up with that though is wanting to make sure that allowing the ADUs and the flexibility of the ADUs doesn't create a problem going forward where they're done and then flipped into a short-term rental.
I mean,
'Cause then
legally,
that
they
kills
can
the
come-
housing
It's-
stuff.
That is gonna happen,
Yeah.
it's just the question, we don't want them both flipped to short-term rental.
Well, we
I-
finally had short-term rentals put to bed, so maybe ABU will come back to bite us.
Oh, yeah.
It'll be a never ending joy.
It's, yeah,
Never ending story. Maybe you should call a special meeting at 11 o'clock this morning and vote on these things now.
it's what. Oh, my goodness. I love
So-
ideas. I think
Uh,
Crystal would be upset.
we got 10:10 as the time. Question is, do we jump into form-based code or how do we address this? Any ideas?
What was handed out this morning?
Just got this.
Yeah.
Just got this, right? And it's
It's
What do we got?
significant.
15, 16 pages long, so
I think you guys might.
Question is, what's the max time you wanna go to, John?
Say that again.
So the question is, what's the max time you wanna go to today?
Or do people want
Well, I think
time?
till
I
10:30.
think people
I think people need-
Back to it.
Because it took, I
What's the
mean,
overview of it? And this is a redo of
I can just give
sections
us
that you
a
feel
quick
need.
summary.
why don't you give a quick summary and highlight the
Yes.
changes? No, I would say not discuss it today,
Yeah, I
but
think we will.
Yeah.
people need to read this, because this took us how many months
A
and
long
multiple
time.
meetings
And then it
and,
took a lot longer than I thought to actually put
Yeah.
it into a document. So, you know, we brought up form-based code last year, that it was time to tweak it, you know, based on feedback from all the applications and everything. So we started in February, the ordinance committee actually went through a lot of the code and had some comments. And then there were comments that staff had. A lot of those were signage and like building materials comments that we had felt that probably could be relaxed a little bit. And then the rest of the changes came through. A few of us have been meeting maybe 2-3 times over the last few months to try and go through the rest of the code and incorporate the information that came from the incentive zoning project with Uptown and just other general pieces of it that felt too restrictive. Some of the, like the table that talks about at what point do they have to come into compliance with the code? How much work can an existing development do in their development without having to change everything, you know, so some of that was relaxed. So after all those meetings, I ended up with a document that had writing all over it. So what you have is page by page listing of what's being changed or what's not being changed. With everything noted in there. There was rather large changes to our review process. That whole section was wiped out and replaced.
That was the biggest problem, I think.
Where there's existing text and only part of it was being changed, you'll see like red text showing what's new or where something might be removed from existing language. I tried to do it with a strike through line. Unless again, it was something really large and then I just said, the whole section's gone, here's what it's gonna say instead. So it's all 79 pages and there's about 15 or 16 pages of changes. Some tables are changing. I tried to replicate the table in this document to show you what the new table is gonna look like. Some tables are coming out completely. But there's blue notes in there throughout trying to explain what's happening. And this is just my collection of all the different conversations. There's a chance I may have missed something or gotten it wrong. I hope not, but, so if you have questions, there's one table I don't have that John is we're gonna compare my notes to his table and then that'll come out separately. I tried to do one, but I could not get it to fit on the page because it got bigger. Simplified it, but it got bigger.
Sarah, does this isn't complete form-based code then?
No, this is just.
This
the
is just changes, so there's still some pertinent.
Yeah, so
verbiage in there.
when the ordinance committee agrees on what you want changed, I think John and I and Mike are gonna work on incorporating it into the existing document. But that's a bigger project because there's a lot of formatting and this was the easiest way just to get the list of changes to me.
but you're gonna need to use your book to review that.
Yeah, compare it against, I mean, we have it on the website, or if you have a printout, compare it
Yeah.
against the existing, because I listed the page numbers of every change.
When we go through it, I have it
And he started.
rudimentary drafts that converted that into a Word document to be able to then actually put some of the draft into the code to see what it looks like.
In the end, I don't know what'll be better, just kind of recreate it or try and change the existing. I know this morning in Word, I was fighting with, they kept putting
Yeah, it's not
tables
the
in weird
best.
places, so.
Yeah, it's not the best way to do, but at least gave us a view as we were going through what it would look like.
Yeah.
But yeah, to actually then come up with a final format, is another story. You gotta figure it out.
But this at least has a list of the changes.
Changes suggested. Okay.
Understood.
Okay, very good. Our next meeting is July 7th. Anything else?
Can I drop one more bomb in the middle of the room?
Sure.
And then walk away? As we walk away?
No.
So I had a meeting, the owner of Twisted Cannabis asked for a meeting regarding the state now allows special use permits for cannabis showcase events. So it's like a 14-day permit for certain locations. He knows that we've opted out. He is asking and if looking at partnering with Star Cider and having a cannabis showcase in conjunction with concerts at FLCC. I will share the information with all of you that I have. You can look at it. See what you think. I told him I'd bring it to the group. I wasn't gonna make a decision on my own or say up or down on my own. We'd bring it as a group. There are other discussions that we would have to have as part of this. One being the county might say they don't support it at all because Star Cider is right on the edge of county FLCC property. Technically, there's no cannabis allowed on FLCC property. They don't enforce it inside the concert venue, but it would be us promoting or working with somebody who's promoting the sale of cannabis at Star Cider with the intent of it going into the county during a concert where it's technically not allowed. So there are a few other hangups that I've got, but I want you to take a look at it, just think about it, and then let me know what you think.
So the question then is, how urgent of a matter is this? Is it something that needs to go on next meeting's agenda?
It takes 45 days. Once, if we were to give approval, the application through the state takes 45 days. So he was hoping to get in for the tail end of the concert season if we were to say yes. So if we got it on the next meeting, then
The likelihood of that happening
is nil, but it would be, if it's not on the, probably would need to be on the next meeting. It's just a discussion for people's thoughts. I don't know that it would be a long discussion. But
at our next ordinance committee.
Yeah.
And then we'd have to go on.
we'd have to amend, so we'd have to amend our local law, say we do it at the next ordinance meeting. Then it would we'd need to set a public hearing to amend our local law. Then we would need to, if we were to actually have that board meeting, so we are looking at 1, 2, 3 months
At least.
from now, yeah.
Before you would be able to make.
Before we'd be able to
Make application.
Which takes 45 days.
which
so
takes
there's almost
45,
5 months.
yeah, so he would
That puts
be,
it into the end of October. so-
he would be into next year's concert season.
Yeah.
So,
It doesn't excite me at all.
Yeah.
Looking for opinions, no?
yeah, if you want,
I'll give you opinion from law enforcement standpoint is the public safety hazard, the people who use cannabis don't believe it causes the same effects as drinking. It's not a good way for law enforcement to detect
yeah, you can't-
people who are driving on cannabis. There's no testing method yet. Other than visual observations. And those venues that have that tend to lead to a lot more people driving high. And.
Yeah.
Legalization of public safety.
I mean, it's there at the concerts.
Law enforcement in mind and the ability to
Yeah.
keep the public safe from it.
I don't think
All
alcohol.
right.
We've already talked about
Perfect.
it here, ordinance committee before.
Perfect.
We were not supportive of it.
Alright, and I mean, it's at the concert anyway, but my big hang up too is. The other liability now that we must face by
Yeah.
something that is being promoted to then take onto the concert venue where it's not legal.
I'm with John,
To
though,
begin
until there's a
with.
detection, way to detect that. like,
Yeah.
Blood alcohol for, it's just not, it doesn't make sense that we would put past our blessing, and I don't really care either way, but.
There's no way to
I need a detection system for, I'm gonna. say
Other than
yes.
brain tissue.
I
And
don't
not a
see
lot of
any
people are
upside
giving
at
up
all
brain.
to it, you know.
Yeah, and when people do talk about the financial benefit.
It's not bad.
It's I think the county the state gets 13%, the county gets 4%, the municipality gets 1%. So of that 13% sales tax that's charged. The municipality would get 1%, and Ontario County is sitting on a couple $100,000 that's come in. And they don't have any, they don't know where to put it because the state's given no direction, so no money is going to Geneva. Victor has it now, and other places that have it. So there's no direction.
So when
with
that
that.
money comes in, you can't just put it into the general fund as a
No, so
source
the
and spend it
county,
wherever you want.
you can, but the
Okay.
county gets it. And then like any sales tax, sends it to the municipalities.
Oh,
So the county is getting the cannabis nut. But no direction as far as the distribution, how it should be distributed to the municipalities.
well, that's my point. So you're getting this money coming in, but you can't use it someplace until the state tells you how.
No, I
Is your
think you can
point?
use it in your general fund. I think you can, yeah. It's just the county can't, the county is waiting because the county is the distributor of sales tax. So they're holding on to everybody's sales tax money from cannabis and haven't been told who gets what percentage or how much.
Why should we get, why
decision?
should we get any if we're not, I mean.
We don't.
Should go to Geneva.
No, it does.
Right.
Could
Exactly.
just go to those.
No,
Where
exactly,
they
but those
said yes to it, yeah.
municipalities aren't
Right.
getting any, because